The federal courtroom in San Francisco fell into a tense silence as Jeff Bridges stood still, his weathered hands clasped behind his back. The harsh, fluorescent lights glinted off his silver-streaked hair, casting a rugged silhouette. From the elevated bench, Judge Edward Chen peered down, his face a mask of icy disdain. "Mr. Bridges," his voice sliced through the quiet, "I've seen many self-represented defendants, but your arguments might be the most misguided I've encountered." A ripple of hushed whispers spread through the gallery. Moments ago, Chen had labeled Bridges' constitutional defense amateurish and an embarrassment to the court, dismissing it with a curt wave. At 68, this seasoned rancher seemed outmatched by the federal government's polished legal team. Yet, what unfolded in the next few minutes left the room stunned, transforming Chen's contempt into shock as he grasped the grave error of underestimating this unassuming man. This wasn't just another land rights dispute, it was poised to become the decade's most astonishing legal clash. Before delving deeper into this dramatic courtroom saga, take a moment to like and subscribe to our channel to stay updated on stories of Americans defending their constitutional rights against overreaching authorities. Now let's return to that pivotal day at the U.S. District Court for the Northern District of California. The atmosphere in Judge Chen's courtroom crackled with anticipation. On one side sat the government's legal squad, 4 attorneys from the Department of Interior, led by Elizabeth Harrington, a Harvard Law alum renowned for her aggressive stance on land use violations. Their table brimmed with organized binders and cutting-edge laptops, a testament to their resources. Opposite them stood Bridges, solitary, armed only with a worn leather briefcase and a stack of well-thumbed legal texts. At 68, he had devoted his life to his family's Northern California ranch, growing it from 80 acres to over 600 across 3 generations since his grandfather bought it in 1946 with World War II savings. For decades, life was peaceful until 3 years ago, when the Bureau of Land Management, BLM, declared 240 acres, nearly half his land, protected wetlands under a new Clean Water Act interpretation, halting all farming and rendering the ranch unviable. "The government wants to seize nearly half my land without paying a dime," Bridges had told local reporters outside the courthouse. "Land my family has worked for over 75 years. I'm not seeking favors, just respect for the Constitution." His choice to represent himself, driven by financial strain from the BLM's restrictions, raised eyebrows. When asked why, he replied, "I lack a law degree, but I've studied constitutional law every night after chores for 2 years." Judge Edward Chen, appointed to the federal bench 12 years prior after a notable civil rights career, was known for his sharp mind and impatience with unprepared litigants. He often favored government agencies in environmental cases, a trend legal observers noted. As the hearing began, his skepticism was palpable. Scanning Bridges' motions, he shook his head. "Mr. Bridges," he said, peering over his glasses, "your motion cites Supreme Court cases with little relevance. I'm concerned about wasting the court's time on baseless theories." Elizabeth Harrington rose with assurance. "Your Honor, our position is clear. Mr. Bridges' land contains protected wetlands under the 2022 Clean Water Act amendments. Our environmental assessment is rigorous and compliant. His constitutional claims have been consistently dismissed by circuit courts." The gallery watched as Bridges, dwarfed by the courtroom's grandeur, straightened his shoulders and spoke with surprising clarity. "Your Honor, I may not have Ms. Harrington's elite education, but I've deeply studied the Constitution and property rights. This isn't just about wetlands. It's about whether the government can redefine private land without compensation." Chen's retort was swift and biting. "Mr. Bridges, emotional appeals about your family's land don't belong here. We rely on legal precedent, not sentiment." Unbeknownst to all, Bridges' unpolished exterior hid a mind sharpened by thousands of hours poring over Supreme Court rulings, law reviews, and constitutional analyses. This wasn't merely a rancher's fight, it was a man meticulously prepared for this moment. The tension mounted as arguments deepened. Harrington presented the government's case with precision, projecting satellite images and environmental reports onto screens. "As these images show," she said, highlighting green zones, "Mr. Bridges's property includes Category 3 wetlands under the 2022 definition, with 17 protected plant species and 4 endangered amphibians. He received 3 warnings, which he ignored." She outlined a timeline of notices and visits, asserting his defiance warranted enforcement. Chen nodded, jotting notes, his demeanor suggesting a foregone conclusion. "Mr. Bridges, your response?" Chen asked, glancing at his watch. Bridges rose slowly, momentarily daunted by the high-tech display. "Your Honor, may I distribute my exhibits?" Chen sighed. "Yes, but be quick." Bridges handed out 3 bound packets, one to the judge, one to Harrington's team, and one for himself. Back at the podium, his demeanor shifted, his voice gaining strength. "Your Honor, the government's case hinges on the 2022 wetlands definition, which I'm challenging. Please see the Supreme Court's 2023 Sackett v. EPA ruling." Harrington interjected, "Your Honor, Sackett applies to specific circumstances, not this case." Chen frowned. "Mr. Bridges, Ms. Harrington is right. You must show relevance." "With respect, Your Honor," Bridges pressed, Justice Alito's majority opinion in Sackett rejected the significant nexus test the government uses. It requires a continuous surface connection to regulated waters for federal jurisdiction. He unveiled a surveyor's map, crafted with a neighbor's help. "This shows no such connection. The seasonal water on my land only appears during rare rains, about once every 7 years. Chen leaned forward, skeptical but intrigued. Even if Sackett applies, which I doubt, the government's ecological evidence holds weight. "That's not the constitutional standard, Your Honor," Bridges replied. "West Virginia versus EPA held that agencies need clear congressional approval for major economic impacts. Ecological value alone doesn't justify federal control." Harrington rose again. "Your Honor, Mr. Bridges misuses unrelated cases. The 2022 amendments authorize our actions." "That's the issue, Ms. Harrington," Bridges countered. "The amendments expanded definitions but didn't address Sackett or West Virginia's limits. This is a major questions doctrine case." Chen's eyes narrowed. "The major questions doctrine, Mr. Bridges, that's a complex theory, even for seasoned attorneys." "Yet the Supreme Court increasingly applies it, Your Honor," Bridges said. "When agencies regulate vast private property based on vague authority, they need explicit congressional backing. The 2022 amendments lack that." Silence gripped the room as Bridges opened another exhibit, satellite images from 1992, 2002, 2012, and 2022. These show no significant hydrological change. What changed was the government's definition, not my land. Harrington, her composure slipping, stood. "Your Honor, he ignores our expert studies." "I'm not disputing the science, Ms. Harrington," Bridges said. "I'm questioning its constitutional basis under Supreme Court precedent." Chen, uneasy with the shift, challenged Bridges. "What about Northern California Riverwatch versus City of Hellsburg, a binding Ninth Circuit precedent supporting the government?" A murmur rose. This was a test to trip up an unrepresented litigant. Bridges responded without pause. "Your Honor, Riverwatch leaned on the significant nexus test from Rapanos, which Sackett overturned. Supreme Court precedent trumps circuit rulings." Harrington countered, "Your Honor, his Sackett reading is too broad." Chen nodded. "I agree with Ms. Harrington. You're stretching Sackett, Mr. Bridges." "With respect, Your Honor," Bridges said, producing a document, "I'm not alone. The Pacific Legal Foundation's analysis shows 6 district courts, including Judge Hamilton's Sierra Club versus Moraine County ruling last year, Applied Sackett, similarly. It requires a continuous surface connection. Chen, surprised, frowned. I know that case, but circumstances differed. The principle is the same, Your Honor, Bridges insisted. Chen's frustration grew. Mr. Bridges, environmental regulations serve a public good. Your rights aren't absolute. My rights aren't absolute, Your Honor, Bridges replied, but they're protected. The Fifth Amendment demands compensation when property is taken. If the government values my land ecologically, they should buy it or pay me, not regulate it into ruin without recompense. Chen's patience thinned. You misunderstand regulatory takings. Not every restriction is a taking. I understand, Your Honor, Bridges said calmly. But Lucas v. South Carolina Coastal Council holds that total loss of economic use is a taking. The BLM's restrictions cover 40% of my ranch, including water access, making it unviable. My analysis proves it. Harrington interjected, Your Honor, he retains some use. Ms. Harrington, Bridges countered, 40% loss cripples my operation. Chen, rattled by Bridges' depth, recessed for 15 minutes. As he left, the gallery whispered, Harrington's team regrouped, and Bridges calmly organized his papers. Upon returning, Chen's demeanor had shifted. With legal volumes and a tablet, he addressed the court. Before continuing, I've reviewed Mr. Bridges' cited cases. Let's address key points. Harrington straightened, sensing a change. Chen turned to her. Ms. Harrington, how does Sackett-Veer's EPA affect your wetlands definition? Your Honor, she said, Sackett doesn't limit our authority over wetlands with ecological ties, even without continuous connections. The 2022 amendments address this. What language explicitly overrides Sackett's rejection of the significant nexus test? Chen pressed. Harrington hesitated. There's no specific wording, Your Honor, but the expanded definitions imply it. So, no explicit language? Chen pressed. Just an interpretation? The intent was clear, Harrington faltered. Chen turned to Bridges. Mr. Bridges, you argue the major questions doctrine applies due to the regulation's vast impact? Yes, Your Honor, Bridges said. Regulating millions of private acres without clear authority is a major question. Chen faced Harrington. Does the government dispute the scale or the lack of explicit authorization? No, Your Honor, but... Harrington began. Chen interrupted. The Supreme Court demands explicit authorization for such impacts. Ms. Harrington, your evidence lacks a continuous connection. Mr. Bridges' survey confirms this. Harrington conceded. The connection is ecological and subsurface. Chen nodded. I've deferred to agencies before, but there are limits. Ecological goals don't justify unconstitutional overreach. The government should use eminent domain with compensation, he ruled. Mr. Bridges raises valid constitutional concerns. The BLM's wetlands claim contradicts Sackett. I'm issuing a preliminary injunction against enforcement and ordering briefing on the major questions doctrine, Sackett's impact, and potential takings under Lucas. The government hasn't shown likely success. The gallery buzzed with shock. Harrington sat stunned, while Bridges stood quietly, vindicated. Chen added, Mr. Bridges reminds us constitutional principles belong to all who study and defend them. His insight transcends credentials. The ruling reverberated nationwide. As Bridges left the courthouse, reporters swarmed him. How does it feel to beat the government's team? One asked. This isn't about winning, Bridges said, tipping his hat. It's about the Constitution working. I'm just a rancher who read the law. Did you expect Judge Chen to shift? Another pressed. He followed the law when shown it, Bridges said. That's integrity. The case, dubbed The Rancher's Stand, trended online with legal blogs praising Bridges' mastery. The Pacific Legal Foundation hailed it a property rights milestone. Judge Chen faced mixed reactions, criticism from environmentalists, praise from scholars for his honesty. At a conference, he reflected, "We must stay open to persuasion, whatever the source." 3 weeks later, the DOJ settled, offering to buy a 60-acre conservation easement at fair market value, acknowledging the rest fell outside jurisdiction. Harrington, humbled, delivered the offer personally. "Your dedication earned my respect," she said, as they shook hands. Bridges accepted, noting, "This is how government should work. Public value means public payment." The settlement set a precedent for balancing environmental and property rights. 6 months later, Chen sent Bridges a handwritten note praising citizen engagement with the Constitution. Bridges framed it beside his family's deed, telling visitors it reflected a nation where limits on power depend on informed citizens. The case spurred law school courses on citizen advocacy and property rights guides for landowners. A year later, Bridges testified before Congress, advocating for constitutional environmental reforms. "The Constitution protects both nature and rights," he said. "It works when citizens know it and officials respect it." His story, captured with his grandchildren on the thriving ranch, underscored that in America, profound constitutional defenses can rise from ordinary people armed with knowledge and resolve. Like and subscribe for more tales of such courage, and share your thoughts below.